Good morning, everyone. On behalf of the faculty, staff, students of the University of Minnesota Law School and the Minnesota Law Review, I'm delighted to welcome you to the 2022, that is the year, Symposium, Law Review Symposium, Leaving Langdale Behind, Reimagining Legal Education for a New Era. I'm Gary Jenkins. I'm the Dean of the Law School, and I want to thank all of you for being with us today. And what an outstanding lineup of presenters do we have for you today. We are really honored to have all of our speakers here at Minnesota Law, and we look forward to hearing your thoughts about legal education and where it's going and where it can where it can go and where we should take it in the future. So this year, our law school is celebrating its 135th anniversary. And we have been an innovator and a leader in legal education in so many ways. So it's really fitting and great to have this convening here with us, and I want to give you a hearty welcome. The Law Review was first established in 1917, so it's not 135 years old, but it's 105 years old. And it's the oldest of our 4 student-edited journals published here at the law school, already into its 2nd century. The publication is well known and respected for its excellence and its rigor. In addition to organizing an annual symposium, they also publish 6 volumes, they host an online publication and a podcast and manage their own affairs, and we are so proud of the Law Review and the students who run it, so I want to give my thanks to all of them. In particular, I want to thank our editor-in-chief, Leah Rimes, and the Symposium articles editor, Joshua Gutzman, for their organization and leadership in executing this event. Will you join me in giving them and all of our volunteers? So this symposium offers an outstanding opportunity for scholars and practitioners and current students to connect and discuss the many changes and opportunities in legal education. This is critically important for those of us who have made our careers as educators and made this essentially our life's work. It's important also for all of us who care about how we shape the process of educating future lawyers and how students experience that process. And it's critically important to the profession and those who are served by it, right? What starts here, what happens here, impacts what happens in the real world. It impacts who the individuals and organizations that are ultimately served by law and what they experience. And as you are all aware, these changes in legal education, they're not prophecy, they're not some distant pipe dream, they're real. They're already here. They are happening, and they are happening fast. From new options for admissions tests to changes to the LSAT to changes in ABA standards affecting the law school curriculum. Significant changes are happening in the bar exam in just a few short years. In addition, we all saw new opportunities and innovations from the pandemic, from momentum around diversity, equity, and inclusion, and particularly in the aftermath of the killing of George Floyd. Now, I'm not quite old enough to have studied with Christopher Langdell. He died in 1906. But I did study in Langdale Hall, which is fitting because it's a beautiful old building. But like any old building, it needs occasional, or if you have an old house, maybe you say constant, renovation. And in fact, Langdale Hall underwent a major renovation when I was a law student. And perhaps the educational model that he left us needs constant renovation, reinvention as well. So I'm not sure that we will ever fully leave Langdale behind, but we will continue to revise and to reinvent Langdale. And in my nearly 20 years as a member of a law school faculty, I think legal education has been doing just that. And certainly in my time as dean, we've been renovating the metaphorical house, changing the way, at least we here at Minnesota Law, support students for the bar exam, for instance. Or members of our law school community have been actively involved in the next-gen bar efforts, which, as you all know, is the most significant set of revisions to the bar exam in most of our lifetimes. We've altered our admissions processes. We've adjusted the curriculum and the course offerings. We've supplemented modes of learning beyond the case method. And some states and schools have experimented with new accreditation models. But like any old house, the work of renovation is never done. And each generation makes its own mark on a given property. And as in any field, taking stock and taking a critical look at what you do and how you do it is so important. And thanks to the Minnesota Law Review, we're gathered today to take that look at legal education. And we're going to think about change and changes and reimagine our future. I'm confident that the work of the presenters today, along with the printed volume that we'll have from this event, will move the needle and will make a significant contribution to this topic. So thanks again to all of the distinguished speakers, the moderators, the guests for attending this conference. We truly appreciate your contribution and presence today. My role here is essentially just to be the warm-up act. I think, I've been waiting to see if we've had any last-minute entrants, and it looks like we're not. So that means I'm done, right? That I've done my job. And so with that, I will just, again, close with where I started, which is with a warm and hearty welcome and thanks to all of you. So please join me in welcoming Leah and Josh to introduce our distinguished keynote speaker, and let's let the important work of the day begin. Thank you.
Thank you so much, Dean Jenkins, for your leadership, for your kind words about the Law Review, and for that wonderful introduction to what is sure to be a day full of engaging and innovative scholarship. Good morning, everyone. My name is Leah Reese, and I am the editor-in-chief of the Minnesota Law Review. On behalf of the Minnesota Law Review, I'd like to thank you all so much for joining us today. Whether you're here in the room with us or streaming online, I'm thrilled to welcome you to our symposium on legal education reform. This topic is universal in the legal community. Each of us, students, professors, current and former practitioners, has been impacted by the education that we have received, and for some of us, that which we impart onto others. But it goes broader than this community. Everyone all across the country is subject to the law. But we are at a crossroads in our understanding of what the law even is. I read a piece earlier this week featuring law professors struggling with how to approach their subject matter and discipline in general in the wake of the most recent Supreme Court term. It's a destabilizing time, and students feel this as well. But it's a necessary reminder that for so many, academics and lay folks alike, the law seems to be a set of dictates handed down from an omniscient source, as opposed to a flexible assemblage of ideas and principles that can be shaped and manipulated depending on the circumstances of a case, the viewpoints of the judge and fact finder, and the particular persuasion skills of any advocates or other involved parties. Looking to our legal history, whether of the past 4 months or the past 400 years, teaches us that nothing about the law is inevitable. People make the law, and therefore people can change it. Law schools, therefore, have a tremendous responsibility, both to the people who pass through their doors and to those who will never set foot in one of their buildings. How are we deciding who has the privilege to work towards this particular education? What does that education look like? And is it actually serving the people receiving it? What about the people who will ultimately be on the receiving end of the product of that education without the benefit of the degree? What paths are we setting law students on when they leave these doors? What does a lawyer leader, as we so love to refer to here at Minnesota Law, actually do? Any institution that fails to reflect upon its own shortcomings fails every person it impacts. And that's why I'm so glad to be here today, amongst people who are asking these urgent questions every day and thinking about how to answer them. So today, I'd like to thank our panelists and moderators, especially those of you who traveled from out of town to be here. Thanks to our faculty advisor, Professor Kristen Hickman, our journal coordinator, Amy Kane, and everyone else at the law school who helped make today possible. Thank you as well to all the members of the Minnesota Law Review for your work. Every staffer and editor contributed their time to this symposium, and we would not have a law review without all 76 of you. Special thanks to Haley Wallace, our lead online editor, for her mastery of Twitter and our digital promotion. And finally, I of course want to thank Josh Guzman, our symposium articles editor, for his months of dedicated work to organize today's event. Since we started working together earlier this February, Josh has been an incredible partner and leader within the journal. As a former teacher, his passion for education shines through whenever you talk to him. He brought both incredible vision and impeccable attention to detail to planning our symposium today, and we would not be here without his work. So with that, I'd like to thank everyone again for coming, and I'd like to welcome Josh.
Good morning, everyone. I think we're getting relatively close to 9 o'clock, so I'll try to keep it pretty short, but thank you so much, Leah, and thank you for your great leadership leading up to this event. Really appreciate it. I also want to say thank you to Dean Jenkins, and to really, I could spend many minutes just listing off all the people that have helped with this event. But specifically, I want to thank Garrett Howe and the facilities staff here at the law school. They've been wonderful. Reiterate our thanks for Amy Kane, our journals coordinator. She has been instrumental to making all of this happen. And of course, my colleagues on the Minnesota Law Review, both staffers and editors of Volume 107, who are all kind of playing behind the scenes roles today, who played many roles yesterday and will continue to play on Saturday. And so we're very grateful for everything that they've done to make this happen. And finally, I want to say thank you to our prior colleagues on Volume 106, those that mentored us and kind of saw in us the potential and the ability to put an event like this on. Particularly, I just want to name Dan Suter, the prior symposium editor. He was just a great mentor to kind of look at the first time having an in-person symposium in a very long time. I'm also incredibly excited to welcome so many speakers from all over the country who are passionate about the future of legal education. We have experts here from all over, from Philadelphia to Phoenix, from New York to LA. We also have North Carolina, Michigan, Wisconsin, Oklahoma, Ohio, New Mexico, and Missouri, all represented in this room. And so this is incredibly exciting to have just that geographical diversity here as well. And of course, we have many thought leaders from this very law school and this town, and our neighboring law school, Mitchell Hamlin. We are so excited to be joined by them as well. And among the attendees, I've noticed that we have folks from the ACLU of Minnesota, folks from a variety of local law firms, and folks from Thomson Reuters, just to name a few. So we've got a great community of people here, ready to learn and engage in discussion. And so thank you all for being here. Really appreciate it. The excitement, for me at least, is really palpable. For myself and my law review colleagues, this is our first in-person symposium, I think, so I've just been incredibly surprised by just the level of energy that I've felt, particularly compared to kind of when we first started out in the pandemic. We were fortunate enough to have some professors that were so engaging that we could feel their energy through Zoom, but being here in person is really something, really something. And I just want to remark on, I've heard from a lot of folks that were surprised by the topic of legal education, and that being a symposium topic, and the excitement that came from that. I think it's a bit unusual for a law review to be focusing on legal education. It's not really doctrinal. It's not really legislation oriented in the way that a lot of law review symposiums are. But here with the Minnesota Law Review, we have a pretty unique way of selecting topics. Instead of, we of course take proposals from professors, but it's not just selecting a proposal from professors. Groups of Minnesota Law Review students actually get together. They imagine a topic that they think will be timely and novel and important and impactful, and then they present to each other and advocate for what they think will really make the biggest change, is the best topic for discussion. And I think my colleagues who were Volume 106 staffers and are now Volume 107 editors really saw an opportunity to seize the moment, and they really recognized the importance of legal education, particularly in the wake of the murder of George Floyd, and also in the pandemic. Folks have realized, there's a real shift going on, hopefully, and they recognize how important really two institutions are to making change. That's the institution of education and the institution of the law. And today we get to really kind of discuss the intersection of those two things, legal education, and what a great place to think about making change. So a very quick rundown of the day. We're going to kind of start from the beginning, the admissions process. We're going to think about what are some ways that we can have lawyer leaders studying to future lawyer leaders who reflect the communities that they're going to serve. And then we will hear about the precious time that those folks who are selected actually spend in the classroom and thinking about curriculum, thinking about legal pedagogy, and how to make the best of that education. And finally, we'll end the day with a conversation about accreditation, and how do we ensure that the folks that are kind of marked with the stamp of lawyer have the ethics, have the intuition, the responsibility that it takes to really make the world a better place. And then finally, I'd like to welcome everyone to a reception at 5 p.m. after that, where we can continue the discussion. I'd be really excited to exchange ideas there. And I should also mention Volume 107's issue 6, the symposium issue, will kind of memorialize a lot of the thoughts that are exchanged here today. And so I hope people will look forward to the publication of that. All right, well, so now, as many education nerds like myself can attest, one of the best places to start before starting at the beginning is actually starting at the end, backwards planning. And so I believe it's appropriate to also start our discussion at the end, or also the beginning in some ways, lawyer accreditation. It's my pleasure to introduce Miss Judith Gunderson. Ms. Gunderson is the president of the National Conference of Bar Examiners, and she's been with the conference since 2000, where she also served as the director of test operations and program director for the multi-state essay examination and the multi-state performance test. Before joining the NCBE, Ms. Gunderson worked in Madison, Wisconsin, at the office of the law firm Foley & Lardner, LLP, before becoming an assistant district attorney in Dane County, in the Dane County District Attorney's Office in Madison, where she worked for 10 years. She obtained her bachelor's degree from the University of Wisconsin-Milwaukee and her JD from the University of Wisconsin University of Wisconsin Law School. Please, everyone, join me in welcoming Ms. Gunderson.
Good morning, everyone. Dean Jenkins, even I'm not old enough to have intersected paths with Christopher Columbus Langdell. Just a second, I'm going to look for a place to put this fire. Well, thank you so much for that nice introduction, Josh, and to Leah Reese and to Dean Jenkins. It's really an honor to be here, and I thank all of you for your participation, and I'm looking forward to the panels later today. As I prepared my remarks for this symposium, I had some help from Associate Professor John Lee, who was recently at the University of Minnesota and is now at the University of Oklahoma. And John, as well, is moderating a panel on the program later today. And John is working on the next gen bar exam. So shout out and thank you to John, and really to everyone here at the University of Minnesota Law School. You've shown so much hospitality. It's been really nice. It's an honor to be here in Walter F. Mondale Hall. The first time I voted was when Vice President Mondale was on the ticket with President Jimmy Carter in 1980. Spoiler alert, they lost. But I was really proud to cast my vote for this pair of progressive leaders, and one of whom hailed from Minnesota. And also, one of my kids went to school here. He graduated in 2014, and so I actually haven't been on this campus in 8 years, but it brought back some nice memories. And of course, a lot has changed over the past 8 years, as the prior speakers have alluded to, but it's good to be back in Minnesota. But most importantly, I'm honored and humbled to be with all of you and to be part of this conversation about how new lawyers are prepared to serve and how we all have a role in preparing them for service. The focus of this symposium, Leaving Langdell Behind, Reimagining Legal Education, is both exciting and timely. At the same time, those of you in legal education, more at the beginning of the journey rather than at the end like I'm at, are reimagining your 150-plus year casebook method of instruction. So too are those involved in the lawyer admissions process, reimagining how lawyers enter the profession. Of course, already there have been a number of reforms in both lawyer admissions and legal education over the decades, and themes have emerged, and I think they're even more relevant today than they were in the past. But it's interesting to see how some of the same themes keep emerging and reemerging. Now, it's an altogether different symposium to talk about the challenges that our democracy faces, but they're on our mind all the time. Erosion of respect for the rule of law, disregard for the truth, and increasing polarization in the debate over what should be our shared American values. I was reading Professor Heather Cox Richardson's daily social media post on September 19th about Attorney General Merrick Garland administering the oath of allegiance to 200 immigrants at Ellis Island on the anniversary of the signing of the Constitution. To our country's newest citizens, he spoke of the rule of law as the foundation of our system of government, but that the rule of law is not assured. It is fragile. It demands constant effort and vigilance. Certainly, as lawyers and law students, we bear even greater responsibility to put forth that constant effort and vigilance to ensure that the rule of law remains the foundation of our democratic society amid foundational shifts in constitutional principles. Leah alluded to this, I think, in her remarks just last week. Slate reporter Mark Joseph Stern noted that the decisions coming out of the U.S. Supreme Court last term and that will be forthcoming in the current term will have profound impacts on how faculty teach the Constitution going forward. The new term will see important decisions on affirmative action, the Voting Rights Act, the interface between religious freedom and LGBTQ rights, and the independent state legislature theory, to name a few. As lawyers and law students, the legal environment in which we practice, teach, learn, and study isn't what it was just even 2 years ago. Where a tenet so fundamental to the common law, stare decisis, is being re-examined and redefined, I have to wonder what Christopher Columbus Langdell himself would have thought about today's unprecedented treatment of precedent. It's become clear in 2022 and beyond that we need to be conscious of how we tend to the health and resiliency of the rule of law in this country. Now, that's quite a list of challenges to lay in front of participants in a symposium focused on legal education, not on the state of our democracy. But if lawyers don't identify the systemic issues we face and seek to solve them, who will? If lawyers don't ask, how can we use the law as a tool to ensure freedom, equality, opportunity, and justice, who will? There is no profession better suited to take on the task of ensuring that our democracy thrives and that all who live in our society have the opportunity to thrive. And this profession, our profession, has its beginnings, its roots in legal education, law students, and law faculty. So the time seems ripe to ask ourselves, legal educators and bar examiners, who have different but related roles in the law student to lawyer continuum, how can we best work both independently and in collaboration to ensure that tomorrow's lawyers are ready to take on the considerable challenges that we face as a society? As Josh noted, I'm here today as the president of the National Conference of Bar Examiners. NCBE is a nonprofit organization that was formed over 90 years ago to bring together now all 56 jurisdictions to engage in discussion, education, and collaboration around a mission set by each of the 56 high courts to ensure that attorneys licensed in the U.S. are prepared to serve as officers of the court. Now, within each jurisdiction, the High Court has established a board of bar examiners or a board of law examiners, and that's the entity responsible to the court and to the people of that jurisdiction to assess two key attributes required of every attorney: the requisite character and fitness to serve clients, and the legal competency required to do so. Today, all 56 jurisdictions use a bar exam as a tool in their assessment of legal competency. Almost all, 52, also require graduation from a law school. As you're no doubt aware, though, there are some notable exceptions. Diploma privilege exists alongside the bar exam in my home state of Wisconsin. In New Hampshire, the Daniel Webster's Honors Scholar Program enables a small number of University of New Hampshire graduates to practice without taking the New Hampshire bar exam. And in California, Vermont, Virginia, and Washington State, it's possible to sit for the bar exam without graduating from any law school, although the number who successfully complete that path is quite small. I mention these two requirements, a solid, proven, and well-regulated legal education, and a solid, proven, well-regulated assessment, to highlight something that I think isn't discussed enough, but I believe is important. That law schools and boards of bar examiners exist, I would argue by design, to perform complementary but distinct functions in the education and licensure of new lawyers. In a 1985 decision out of New Mexico, matter of Adams, that state Supreme Court found that the assessment of legal competency could not rest on just legal education alone or on just a bar exam alone. In a unanimous opinion authored by then Senior Justice Dan Sosa Jr., who parenthetically, before he became a member of the New Mexico High Court, founded MALDEF, the Mexican American Legal Defense and Education Fund, in 1965. The court held that both a rigorous legal education and assessment through a bar exam were necessary. The court referred to them both as integral parts of a two-pronged evaluation process. This evaluation process, completion of an approved course of education and success on a licensure exam, is common across most professions, including nurses, dentists, physicians, CPAs, engineers, pilots, and so on. Now, the role of NCBE is to serve the high courts in fulfilling their obligation to admit lawyers. Our NCBE team, which includes lawyer editors on our staff, along with a large network of volunteer lawyers, judges, and faculty members from across the country, develop the bar exams that most jurisdictions use as part of their admissions process. NCBE is at its core both a service organization and a testing organization. Yes, NCBE develops the bar exam, but at the heart of that work is the shared goal of the bar admissions community to promote fairness, integrity, and best practices in admission to the legal profession for the benefit and protection of the public. And I have to believe that these goals are shared by the legal educators here as they work to educate future lawyers, judges, and leaders who pass through these classrooms. So a theme of this symposium is reimagining or evolving the way we do things, both in legal education and in bar admissions. And as I believe Justice Sosa would have agreed, the two exist in a state of complement to each other. This is borne out by the work that will be discussed, that I'll discuss a little bit later in my speech, and also the efforts begun in 2018 to evolve the bar exam to ensure that it will continue to have fidelity to entry-level practice. Both efforts in legal education reform and bar exam evolution seek to reflect changes in the legal profession, and ultimately each will serve to strengthen our profession as well. So as the speakers alluded to, there are significant changes coming for the bar exam. And so while that's the case, this isn't the first time that the bar exam has changed through the years. The multi-state bar exam was introduced in 1972, followed by the multi-state essay exam in 1988 and the multi-state performance test in 1997. In 2007, MBE topics were added to the MEE. In 2015, civil procedure was added to the MBE, and negotiable instruments was eliminated from the MEE. And along the way, we have amended subject matter outlines to better reflect the law or to simplify or clarify what is being covered on the exam. And we've conducted periodic practice analyses, which I'll talk a little bit more as I talk about Next Gen. We've done those in 1982, 92, 2011, and 2019. But exam content isn't the only thing that has changed throughout the years. In response to an increasingly mobile cross-jurisdiction profession, NCBE led efforts to envision and implement the Uniform Bar Exam, which is in effect here in Minnesota. The Uniform Bar Exam has now been adopted in 41 jurisdictions, and what it does is it allows for score portability for newly licensed lawyers. That is a feature of the UBE that was virtually non-existent 11 years ago before it started. To date, not including a lot of people from the July exam because results are still coming in, over 215,000 people have taken a uniform bar exam, and over 41,000 people have transferred scores to a second or third jurisdiction. So that's over 41,000 bar exams that didn't have to be taken. As with past innovations in the bar exam, we're developing the next gen bar exam hand in hand with legal educators, the courts, and the larger legal community. This multi-year project began in 2018 under the leadership of the Honorable Rebecca White Birch. She was the retired Chief Justice of the Arizona Supreme Court, and may be of particular interest to the people in this room. Chief Justice Birch was the former director of the legal writing program at Arizona State University College of Law for several years in the 1980s and the 1990s. In 2018, Chief Justice Birch was the chair of NCBE's Board of Trustees. That's the governing body that guides the work of NCBE. Our board is made up of a diverse group of Supreme Court justices, federal and state court judges, attorneys, bar examiners, bar admissions administrators, and legal educators. Set to debut in 2026, the Next Gen Bar exam will feature testing of a broader range of foundational lawyering skills, utilizing a focused set of fundamental legal concepts and principles. This new exam is designed to balance litigation and transactional skills and settings, and will reflect many of the key changes that law schools are making today, building on the successes of clinical legal education programs, alternative dispute resolution programs, and legal writing and analysis programs. And while legal education does not drive the content of the bar exam, and the bar exam doesn't likely drive legal education curriculum, both have identified a shared set of foundational skills that are critical to the competent and ethical practice of law. The importance of lawyering skills has been a theme of legal education study and reform for decades, made even more essential today as large law firms have cut back on their own training programs. Many new attorneys start out in practice in smaller firms with government or as solo practitioners. In his website, Legal Evolution, University of Indiana professor Bill Henderson recently wrote about the impact that remote and hybrid working arrangements are having on the number of opportunities for new lawyers to have in-office interactions, collaborations, and learning experiences. The bottom line is we can no longer assume that the first few years of a new attorney's practice will involve the amount of professional mentorship and support that once existed, that probably many of us enjoyed. And bar associations and law schools have sought to fill that gap, but their programs can go only so far. Of course, law schools have long focused on teaching lawyering skills and also on fostering professional identity in students. And recently, the ABA section on legal education and admissions to the bar revised accreditation standard 303B to require schools to provide substantial opportunities to students for the development of their professional identity as lawyers. In their new book on professional identity formation for law students, Professor Neil Hamilton from St. Thomas's Halloran Center and Dean Emeritus Louis Bilionis of Cincinnati Law stressed that professional identity formation starts in law school and continues as the law student becomes the lawyer. Professional identity, they say, is that a student understands, internalizes, and demonstrates a commitment to serving clients, the profession, and the rule of law, as well as a commitment to continuous professional development toward excellence in the competencies needed to serve others in the profession's work. So while state Supreme Courts and bar examiners and admissions boards have different roles from the legal educators in attendance here today, we all share this professional identity and commitment to the rule of law and striving toward excellence in all the competencies needed to serve. And we all know that lawyering skills, being a lawyer, matter to competent service. As I prepared for this symposium, I ran across a passage published in the University of Pennsylvania Law Review, and here's what it said. Today's law students are, on the whole, brighter, more outspoken, and more impatient with social injustice and institutional inertia than their predecessors. That's true in a nutshell, isn't it? When do you think that passage was written? This year? Last year? 2020? Not even close. It was written in 1971. 51 years later, it's still true. I think that law students are always likely to be impatient with injustice and bright. And I think that's why they go to law school in the first place. And I think it's lucky for us that that's the case. And I hope as lawyers, we share that impatience. Back when that Penn Law Review article was written, some of the cutting-edge proposals for legal education reform included clinical work, skills training beyond merely thinking like a lawyer, or asking simplistic questions about the arguments for and against each party. The author, Professor Robert Gorman, went on to write about dispute resolution by negotiation and mediation, document drafting, and information gathering. He also mentioned interdisciplinary study and bringing in other disciplines such as data analysis, economics, and public policy. Some of these themes regarding the importance of teaching and learning lawyering skills also came through loud and clear in the publication of the seminal McCrate Report in 1992, also published by the ABA section on legal education and admissions to the bar. The central message of that report was that legal educators, practicing lawyers, and members of the judiciary together are engaged in a common enterprise, the education and professional development of a great profession. At the heart of the common enterprise is the development of the lawyering skills and professional values essential to a competent and responsible profession along a continuum that starts before law school, reaches its most formative and intensive stage during law school, and continues throughout a lawyer's professional career. I think the McCrate Report had a large influence on legal education in that it underscored the importance of teaching foundational skills. I will tell you that the report had a profound impact on the bar exam. Prior to the McCrate study, NCBE had co-sponsored experiments with the California Committee of Bar Examiners, producing a California-specific performance test. But it wasn't until the McCrate Report was published and called for greater emphasis on skills training for law students and recommended that the bar exam include skills testing that the momentum shifted nationally. NCBE, working with a pioneering team of clinician drafters, developed the multi-state performance test, the MPT. The McCrate Report was published in 1992, and in February 1997, 4 states administered the MPT for the first time. In July, another 4 states administered the MPT, and the rest is history. Today, the MPT is administered in 49 jurisdictions, and it assesses 6 of the 10 McCrate skills. 15 years later, in 2007, yet another study was released, which also emphasized lawyering skills, and that was the Carnegie Report. This report lauded law schools for the rapid socialization into the standards of legal thinking, mainly through the Langdellian case dialogue method of testing. That's a mouthful. I have to tell you that that concept really hit me hard when I walked into this room. I was telling Leah and Josh, if you're like me and you haven't been in a law school classroom in a few years, this brings a lot of that Langdellian case dialogue method of teaching back into my memory. One of the studies, the Carnegie Studies authors, was a recently deceased and highly regarded University of North Carolina School of Law Dean and Professor Judith Welch Wagner. She wrote an article in NCBE's quarterly magazine, The Bar Examiner, in 2011, and she cited many examples of curricular innovation, including instructional designs that focused on applying legal principles to complex social problems. 11 years later, here at the University of Minnesota Law School, there are over 25 legal clinics, and over 50% of the students here participate in one or more clinics that are focused on business and nonprofits, economic justice, family and community, human rights and immigration, and rights and liberties. Dean Jenkins secured the largest gift in the law school's history to fund an integrated set of clinics focused on the rights of new Americans, immigrants. The work that the students are doing here throughout their clinical experiences to advance justice are challenging, important, and transforming. Through the decades, we have seen a trend toward more skills instructions, experiential learning, formative assessment, and recognizing the importance of preparing for being a lawyer, not just thinking like a lawyer. Now, thinking like a lawyer, everybody talks about that. And, there's a movie that for many of you, of course, are too young to know, but maybe you've seen it. And for many people, this movie shaped what people thought law school was like. It was called The Paper Chase. And the great actor John Houseman plays a quite intimidating, I would say, Professor Kingsfield, who excelled in the use of the Socratic method in Langdell Hall. He famously tells his first day class of 1Ls, you come in here with a head full of mush and you leave thinking like a lawyer. Now, I don't think that part is true, the part about, the head of mush. But it is a famous line, and it underscores what that 1L experience has been like and what the Carnegie Report referred to. Professors using the Socratic method, along with case law pedagogy to teach new law students how to think like a lawyer. As I mentioned, when I walked in this room, it brought back memories, only being slightly terrified for the entire first year, waiting to be called on. Is thinking like a lawyer enough, or should the focus be on doing or being a lawyer? That question was asked by then Dean Nancy Rappaport from the University of Houston Law Center in a law review article she wrote in 2002. No one, she wrote, expects a newly licensed doctor to think like a doctor rather than be a doctor, or for that matter, air traffic controllers, scientists, mechanics, or engineers, she continued. The explosion of legal clinics, participation in legal clinics, externships and simulations over the past few decades is evidence of law school's commitment to skills teaching and being a lawyer. And of course, the ABA standards and accreditation require that all law schools have at least 6 credits of experiential learning. As I think many of you might know, clinicians play an important role in the development of the current bar exam and are also deeply involved in the next-gen bar exam development. One of these clinicians, associate professor and director of the Veterans Legal Clinic at the University of Georgia School of Law, Alex Schur, told me what he means when he says thinking like a lawyer. Thinking like a lawyer includes what a student learns in the law school classroom, finding, reading, and analyzing the law, thinking from multiple perspectives, and applying legal rules to given facts. But it includes much more than that, working with incomplete and uncertain information, understanding the history and human context of the client's concern, assessing social and interpersonal realities, and listening attentively to the client's goals and needs and values. Then, the lawyer needs to integrate all of these realities into a plan of action that produces the best possible outcome given the limitations of time, money, and energy. Well, that sure sounds like being a lawyer, not just thinking like a lawyer. And it incorporates the important skill of listening, understanding the whole client, and finally, but importantly, taking into account real-world constraints. When I thanked him for responding to my query about what thinking like a lawyer means, he said, "Oh, it's why I love my job so much." And I'm guessing that there are so many law teachers in this room today who feel the same and inculcate these same values, perspectives, and guidance to law students every day. In 2014, the Institute for the Advancement of the American Legal System published a study called Foundations for Practice. In this study, researchers asked lawyers to indicate whether 147 different characteristics, professional competencies, and legal skills were necessary immediately out of law school, could be acquired over time, were advantageous but not necessary, or were not relevant. The results of this study indicated that new lawyers are most successful when they come to the job possessing 76 formations that were then categorized into 5 broader categories: communicator, practitioner, professional, problem solver, and self-starter. Now, while the bar exam cannot fairly or objectively test for some of these attributes or values, that does not diminish their importance to the newly licensed lawyer. It is these professional and personal values that law schools impart to students as they progress from law students to graduates. So for decades then, we've all realized that lawyering skills are important and the values that we share as lawyers are important. You know, going back to Professor Wagner, certainly she asked bar examiners throughout the years, how does the bar exam know what it should be testing? Are you testing the right things? And we've been asked that, of course, by many others. I want to talk a little bit about the principles that we follow in identifying the competencies tested on the bar exam and in developing and scoring the bar exam. These principles are set forth in the standards for educational and psychological testing. This is an open source text, so you can refer to it. It's published by the National Council on Measurement in Education, the American Educational Research Association, and the American Psychological Association. Tests, especially high-stakes tests like licensure tests, like the bar exam, have to be fair, valid, and reliable. These fundamental qualities of any licensure scheme are detailed in the standards, and they guide the work of a category of test measurement specialists known as psychometricians. And while the content of the bar exam, the questions themselves, are written by legal experts, psychometricians are the experts in the standards, which help guide our exam development and scoring and ensure a fair, valid, and reliable, and ultimately defensible exam. NCBE has a team of psychometricians, and in fact, one of our psychometricians, Dr. Danette Waller-McKinley, is here today, and she'll be on the last panel of the afternoon. One thing I want to ask people about is, do you think that the purpose of the bar exam or any licensure test is to gauge successful performance in practice? It is not. First of all, it would be very hard to measure successful performance. Is it by the number of satisfied clients? By a lack of dissatisfied clients? Does it depend, is it evidenced by a lack of disciplinary complaints for incompetence rather than ethical violations? And how much might a lack of disciplinary complaints depend on which jurisdiction an attorney is practicing in and the consistency of its disciplinary practice or the sophistication of the clients? Licensure examinations in any profession cannot and do not evaluate all the attributes needed for effective practice over a career or even in the first few years of a career. Traits like honesty, conscientiousness, and diligence are clearly essential for a candidate to practice effectively. Although these attributes are not tested on the bar exam, they're examined during the character and fitness process. Again, these 2 prongs of the admissions inquiry are complementary but distinct. Now, of course, adhering to measurement standards of fairness, validity, and reliability isn't enough. NCBE works closely with outside content experts, including some of the professors and practitioners attending this symposium who develop the exam content. These dedicated volunteer drafters hail from all over the country. Over 35 law schools are represented, and when external reviewers, which all of our items are reviewed externally, when external drafters are added to the mix, most law schools in the country have had 1 or more people involved in bar exam development and vetting. The drafters who write the current exam and those who are working on the next gen exam set a good example for how practitioners and judges can work closely with faculty members to create high quality assessment tools that reflect the knowledge, skills, and abilities needed for success in today's changing legal profession. But our outreach and involvement with legal educators extends well beyond drafting the current bar exam. So when we started, when Chief Justice Birch tasked our board and our staff with reimagining the bar exam, we started by listening, and I hope we listened like lawyers to all of our stakeholders. As an example, NCBE had multiple listening sessions during the Association of American Law Schools January 2019 conference. And over the course of the next year, we listened to over 300 stakeholders: courts, admissions offices, bar examiners, legal educators, bar associations, affinity bar associations, to hear what they liked about the current bar exam, what they didn't like, and if they were reimagining the bar exam, what they would want. No, blue sky thinking. The second phase of our next-gen test development was a nationwide practices that consisted of surveying newly licensed lawyers and those who supervise newly licensed lawyers to gather empirical data on the knowledge and skills required of our newest colleagues. For this practice analysis, we received substantive, thoughtful input from about 14,000 attorneys from every state in the country and all different kinds of practices: solo practitioners, in-house, public interest, government, private firms. If you have followed practice analyses in other professions like dentistry, nursing, or accounting, or California's 2018 or Florida's 2022 legal practice analyses, you're aware that an empirically based practice analysis ensures that exam content is aligned with entry-level practice. And this data-driven practice analysis approach is set forth in the standards that I mentioned before. California and Florida had similar practice analysis results as the NCBE practice analysis, and all these practice analyses are available online if you want to take a look at them. So following the listening sessions and the practice analysis, what did we do? We convened test design and test blueprint committees composed in part by deans, academic support staff, and faculty members, again, some in this room, to review the practice analysis, the focus group feedback, and then recommend to us what to test on the exam and how and when to test it. And in the past year, more dedicated and talented volunteers, again, I sound like a broken record, but people in this room, including members of the Legal Academy, have helped us define and refine the proposed content scope to be covered on the next gen bar exam. So what did the practice analysis and listening sessions tell NCBE and the blueprint design and content scope committee members? Well, no surprise here that we should test more skills than are assessed currently on the MBE, MEE, and MPT. That the exam should focus on the most important doctrinal areas, reducing the number of testable subject areas. That being a competent lawyer means having enough foundational knowledge to be able to ask the right questions, to understand what else has to be known to ask the right questions, and to properly assess the situation, and to engage in effective research, and then synthesize all of the above to effectively counsel a client or to respond to a matter. And of course, that being an ethical lawyer and having cultural competency are critically important. In many cases, the doctrine and skills to be tested transcend specific practice areas and subject matters and cross over between litigation and transactional practice. I encourage you to visit our website, nextgenbarexam.ncbex.org, to read the report on how the content was developed using empirical data, qualitative input from outside experts, and a focus on fairly testing the skills and knowledge that stakeholders and the data showed us were most important. So the Next Gen Bar exam will test content and skills in an integrated exam format on computers, which permits the use of scenarios that are representative of real-world types of legal problems that newly licensed lawyers encounter in practice. The 7 fundamental lawyering skills to be assessed on the Next Gen Bar exam are legal research and writing, client relationship and management, investigation and analysis, client counseling and advising, negotiation and dispute resolution, legal writing and drafting, and issue spotting and analysis. These skills will be tested in the context of a more focused set of subject areas, the 7 MBE topics, which are federal civil procedure, contracts, criminal law and procedure, constitutional law, evidence, real property and torts, and business associations was added to the topics to be covered. And again, this was a result of the information that we learned from the practice analysis and from the focus groups. Now, considering the breadth and depth of the knowledge to be tested on the new exam, the committees evaluated 6 key factors: frequency, universality, risk, complexity, context, and stability. In the next gen bar exam, if you look at the proposed content scope outlines, because they're not finalized yet, you will see that there are different levels of knowledge that will be required. There's level 1, where you need to know enough to spot the issues and to work with resources that will be provided. An example of this, let's say in civil procedure, might be you need to know that supplemental jurisdiction is a thing. Do you need to know how to deal with it without looking at the rule? No. Level 2 knowledge is where you have to know the doctrine. So in an example, again, using civil procedure, you have to know what diversity jurisdiction is. So that's how the judgment of these committees went through and looked at all of the topic areas. And within the topic areas, how these subtopics should be treated. I should also tell you that if you look at the current outline scope, some of the topics that remained on the exam, so let's say within civil procedure, some of the topics to be tested have been recommended for elimination. Again, you can look at all of this on our website. For anyone taking the exam also, so while some of those topics were added to what will be on this exam, other topics were eliminated. Trust and future interests, family law, Article 9, secure transactions, and conflict of laws. Those topics will no longer be tested on the next gen bar exam, again, because the data in the practice analysis showed that they weren't performed consistently by enough of the newly licensed lawyers. So to give you a quick update on what are we doing now? Well, we continue to refine and define the content. We published the proposed content scope outlines back in, I think it was in March. I'm looking at Debbie Merritt because she was on that committee, John, in March, and we gave people 3 or 4 weeks to comment on that. And most of the comments were from, this won't surprise you, legal educators. And we got over 600 comments opining on what we propose for the new content scope outline to be. We're working through those comments, and we're trying to refine the content to make sure that it's crystal clear for people who are taking this exam that they know what they need to study. We are in the thick of developing items and item sets. Working on the skills item set development is something that just happened, I think, a week or 2 ago. And we have these subject matter experts, outside people writing these exams, these questions. We have these retreats, and we've had a few of them, and we plan to have a few more. We're engaging in a lot of outreach to the Legal Academy and to our other stakeholders and to jurisdiction boards and courts. So far, I mean, starting from June, and I think going through about January, we will have had about 21 appointments with state boards of bar examiners and or courts, and sometimes law schools appear at those sessions as well. So we're engaging in a lot of outreach and have had a lot of interest and enthusiasm for the next gen bar exam. And we're also engaging in pilot testing, which I'm going to talk a little bit more about in a minute. And then, of course, there's a lot of under the hood work that we're doing at the conference. A lot of systems work, finding technology partners, and just planning out over the course of the next, not quite 4 years, what all needs to be done to make sure that the exam can debut in July of 2026. So as we move to the vetting and refining part of the test development, I want you to know that we reaffirm our commitment to building and delivering an exam for the future that is accessible to all. As people of good faith can disagree about the use of equated tests, tests with score stability across administrations in admissions to college, law school, and for admission to the bar. I think it important that you know that NCBE is doing all that we can do to promote opportunity for all would-be lawyers to enter the profession and serve. Our mission is to promote fairness, integrity, and best practices in admission to the legal profession. And as part of our vision for a competent, ethical, and diverse profession, we take very seriously the need to work toward greater equity in all that we do as a testing organization. And we actively work to eliminate any aspects of our exams that could contribute to differences in performance among groups. We maintain high standards in developing our test questions through the work of our diverse group of drafters and external reviewers who are supported and trained by experienced lawyer test editors and measurement professionals. And as we work to implement the next generation of the bar exam, we are committed to producing an exam that fairly assesses all candidates. And as we proceed with test development in the next gen bar exam, we are using authentic lawyer-client interactions to role model good, effective lawyering. It means honoring the client's story, their lived experiences, and the ways in which we need to be not only client-focused, but client-centered. It sounds pretty similar to what Professor Schur said about what it means to think and listen and be a lawyer. So currently now, with the exam, the next gen exam, we're preparing to launch a series of essential pilot and field tests, which serve to vet and refine the content, format, timing, and delivery of the new exam. A large pool of diverse candidates from law schools throughout the country will sit for simulated exam sections designed to establish how the new question types will work. How long will they take to complete? What resources might examinees need? And giving examinees all the same resources. So that's the kind of open book that we're providing rather than leaving it to each individual. And how good a job do the questions really do in testing the skills and knowledge that we are tasked with assessing? We'll report back to the legal community as we learn more about the best ways to administer the new exam to ensure a fair and accessible exam. We've already conducted a pilot test, and our next pilot test is scheduled for early November. We pledge our efforts to continue to listen, learn, develop partnerships, and identify concrete ways that we can take action to promote greater diversity and inclusion in the legal profession, and specifically in bar exam success and bar admission. I hope that the next gen exam can help align curriculum and licensure to prepare today's law students to think and listen like, and to be tomorrow's lawyers. These are times of change in our country, legal education, and admissions. I salute the participants of this symposium for their dedication to legal education and to the legal profession. And I hope that it remains, and as lawyers, we remain the defenders and champions of the rule of law. And I hope that we remain impatient with injustice. Thank you so much for this opportunity. I look forward to the rest of the conversation today.